What do you got?
I think I can prove to a judge that both of these men had the mens rea.
What the hell is a mens rea?
It's a legal term the lawyers use. It just means the intention to commit a crime.
Okay, come on, let's go.
Mens rea?
Put the cuffs on him.
How could we have gotten mens rea? We take blood? Can you do it without taking blood? We both use condoms. How is this possible? I want to see a doctor. Can I have an independent blood test?
Money!
I feel sick.
What are you doing?
Mens rea! My God!
Everything that guy just said is bullshit. Thank you.
How dare you?
Hey, missed it by that much. How are you doing, everybody? Hi, it's me, Legal Vices, and it's Megan Fox in the dark.
Is it looking too dark in here? I can turn it up. I can turn the lights up. Is it dark?
It's looking shadow. You're a shadow figure. You're blue. Hey, blue.
Well, let's see. Let's see if I can make it a
I'll
little.
have a blue Christmas without you.
There, how's that? A little brighter?
A little brighter.
Brighter.
Turn it back. Turn it back down. Oh God, turn it back down. Just kidding. I was like,
No, this is not okay.
just kidding. He
Stop
says while we're-
trolling me, Jeff.
Yeah. No, anywho. Hi, people. Welcome to my little old channel, Legal Vices, for part 2 of the exclusive new Take Care of Maya defense motions, for directed verdict, new trial, reduced damages. We did part 1 yesterday for a couple of hours and a little bit more. We got to wrap it up today. It was a 144-page motion. And we're clearly not doing all 144 pages. We're skipping around through it. We're working our way towards some of the darker bits. We vented a little bit. We've had a little cooling off period, hopefully, where we won't get hysterical like a typical woman and get the vapors and all these other things. And because, ladies and gentlemen, Reddit's angry.
Oh yes, Reddit's very angry with us.
And it's just basically because we got it first. But look, I didn't know this rabid Reddit group existed, and I know you guys are watching. I just want to say hi. I don't want this to be an echo chamber. I don't want it. You know, say how can they not? No, I am giving my views of this. I don't have to. Well, I think they've got a point there. We're not here to talk about the right points. We're here to talk about the problems with the motion. And I didn't even know this Reddit thing existed, this Reddit group, this subreddit.
Well, strangely enough, this is the Reddit group that Ethan Shapiro basically got all of his information for his motion for a new trial from. These are the people who are investigating the juror and the juror's wife and doing all this stuff, which is really invasive. And frankly,
that would explain why they're unhappy.
I think
every single lawyer that saw the motion for a new trial thought it was laughable. That would explain that.
But I think they should think about the fact that what they are doing could be considered juror intimidation for future trials. Who the hell is going to want to sign up to be a juror if your entire life in social media is going to be picked apart by a Reddit page? And I think they should think twice about what it is that they are doing, because they're making it very, I don't know, unpleasant for jurors. And neither of this man, juror number 1, there's no evidence he did anything wrong. There's no evidence he spoke to his wife about the trial. So what? She's interested in it. So what? She's pro-plaintiff. There's nothing there. And what you're doing is you're making it very difficult for future jurors to want to be in the process. So consider that.
Chances of them changing their ways are slim to none. But listen to Internet Mom. She knows what she's saying. But I mean, I don't want this to be an echo chamber. I really don't. It really takes a lot of fun out of it when it's just a bunch of people going, yeah, what she said, what he said, yeah. But I was noticing one thing, because they're like, oh, wouldn't that be funny if they came here and they read our reactions? I mean, one, it's not worth my time, really. Two, they were lame, because there was probably 100 different comments I read about, how did you get it first? How did they get this motion before anybody else? Why wasn't you? Or maybe they gave it to others, but they were smart enough not to talk about. No,
no one else has it.
It was a good chunk of just whining about us having it first because sources, and 2, You're a shrill banshee. I'm a maritime lawyer guy that has no business talking about civil damage
You're
cases.
the two least
Yeah.
qualified people to talk about this. Jeff.
Yes, I saw that. I saw that one. And
That's
spoiler
my
alert
favorite.
for those of you that are watching, a large portion of what I do in the maritime law field is personal injuries, crew injuries, because when ships bump into each other, people get hurt. Being a crewman on board a ship is an incredibly dangerous thing. People get injured all the time, and that's a huge part of what I do is calculation of damages, both economic and non-economic damages. So I might be a little more qualified than you think, but I still went to more law school than you did. Yeah. So I'm kind of smart, and she's medium smart.
I'm medium smart. Yeah. Nobody says I'm the smartest one in the room.
Yeah.
Certainly not. But I do.
Smart.
I do have sources who send me fun things before anybody else gets them. Occasionally, that's the perk of being a journalist. When I'm researching things, sometimes people decide, you know what, I like her coverage. Here's some more stuff. And that happens a lot. In fact, I've got another one from Lehigh Valley, Pennsylvania, all that big scandal over there. I've been contacted by some seriously great sources there, and I've got some stuff in my inbox that would blow your mind. I just can't talk about it yet. But when I can, it's going to blow everybody's mind. It's so bad. So that was such a good insult, Jeff. I loved it.
I thought it was amusing. It was just one of those spur of the moment things. But again, as Reddit people, I know you're going to be watching this because this is your only source for hearing about this right now. It's right here.
And you have to watch it. One of my favorite comments on the thread was, I just muted it and read along. So I didn't have to hear her talk. Because,
I get the views anyway. Please continue to do that if you see fit. We, as I mentioned to someone, it's that I like the dissent. I like to hear alternate theories, alternate viewpoints, because it makes me think, it makes me question. But so about 1/3 of it was, these are the two least qualified people to be discussing this. About 1/3 was they got it and we don't. Yeah.
I don't like her voice. How come she got it first? None of it was legitimate criticism.
Well, that's what I was saying. Yeah. It's like 1/3 was we hate you guys. 1/3 was just we don't have it. And the other 1/3 was, is this real? I saw zero comments on anything to contradict what we were saying. Nobody offered any counter to the commentary that we were providing. I mean, don't just go into the atmosphere. Have a take. Tell me your take, and a reason. Not like you just suck ass because you're a bunch of dickheads. That's not a valid opinion. Well, it may be a valid opinion about me, but not particularly the analysis I'm giving. Have a reasoned discussion. I'm all for it. Unlike others, Megan Fox, I'm not deeply invested in this. I'm just disgusted by the whole thing as a lawyer looking at the behavior and actions of another lawyer. And like I tell people when I cover the trials, it didn't happen to any of my family, so I really don't care if this person did it or not. If they did it, I hope they go to jail for the rest of their life and are buried 6 feet under the prison. If they didn't do it, I hope that they're acquitted. But whatever, it's up to, is it a fair process? Are they given due process? Is the prosecution acting in a fair manner? Are their constitutional rights being protected? If they did it and they're being railroaded, evidence is being falsified, shenanigans are being pulled, I hope they walk, and that lives on the conscience of the prosecutors forever. I'm concerned with the process.
Right. Me too.
And this is the behavior of defense counsel in this is reprehensible in a lot of ways. And that's what I'm here to talk about.
Agreed.
What about you, Megan?
I just think it's funny making them angry. I don't know. My mere presence makes them angry. So, whatever. I have that effect on people. They either love me or they hate me, and there is no in between, and that's okay. You're welcome to feel that way.
Well,
As long as they watch me, I don't care.
Yeah, turn off the volume, please. Just keep it rolling. Put it on repeat. You know, read it slowly. I don't know. But see, the first thing was just in the Twitter announcements. There was somebody posted a response to one of my tweets or one of my X's. I'm never going to say that. That's so stupid.
I'm never going to say that.
Yeah. One of my tweets. The response was, "Well, the anti-Maya Reddit group sure is upset," or something. And with the what now?
What now?
I learned about you guys shortly after you learned about me.
Yeah, I just saw it for the first time yesterday when I sent you a couple of those screenshots. I was laughing. And it's interesting. I went on there and I did look through quite a bit, but they're not giving me anything substantial as far as what their argument is, other than they think this family are a bunch of lying grifters. I just don't know where they come up with that, though. I don't know where the evidence for that is. To me, the evidence is all on the side of the hospital really screwed up and they don't want to admit it. And, yesterday in the filing, didn't we read? I think the most shocking thing we read was, well, we may have dropped her, but oh my God, we transferred her from one bed to the other pretty roughly and may have dropped her, but
may have been a rough handling. It may have been dropped in.
Wow.
But hey, that's okay because there was a crazy woman with a 3 foot. Was a 3 foot cross? Is that what it was?
It was Mary, a statue of Mary.
Okay.
That was the traveling Mary.
All right, they just said religious icon. I'm like, well, it kind of narrows it down. I mean, it's got to be one of the two, a crucifix or Mary.
Did you ever see her testimony? So
I didn't see hers.
From church. She was wearing the hat, and she was the woman from church, and she brought the traveling Mary. And when she said she got kicked out of the room, they asked her, "Who kicked you out of the room?" And she goes, "I don't know, but it was like a dark force behind me." There was a dark force and it said I had to leave. And we were kind of chuckling when she was going over, because she was really like early on in the testimony. Then the 7th floor coven witches keep getting on the stand and we're like, holy shit, there really was a dark force. And it was all these bitches with the black hair dye and oh my Lord. I mean, it's just this, you couldn't have made this any better. This trial, the witnesses, the jokes wrote themselves, folks. And I'm sorry, Reddit, that you didn't get the joke. And I'm sorry you weren't able to have fun with us, but we had a blast.
Yeah.
They're not having fun over there. They're just like rolling around in misery.
Oof. Yeah. So we're doing, Hey, Rob, Law and Numbers here. This is the new motion that I don't think has actually even been dropped yet on the site. You were going to check to see if it had been posted on the docket. Is it there yet?
It's not there yet.
Okay.
Did you see what Rob just said? Are we talking about the motion that couldn't have been proofread? The motion with all the admissions? Yeah, that one. Especially page 59, where the admission was that the pictures were taken not for any medical purpose, but for Sally Smith, which is what they argued in 100% the opposite direction. Incredible.
Well, let's we got about 50 some odd pages, 51 pages to get through, I believe. Here
we can do it. We can do it.
Because it's already 1:30 a.m. here. They just
Holy shit.
My Maritime Monday show. The T-Rex trucking and more. We're going to do these in batches again. So we'll give you all the big foghorn for the support. Hey. T-Rex Trucking and More says, hey, let's do this thing. Happy Monday/Tuesday. Legal, the Larax Vices, and Megan Medium Smart Fox. Thank you, T-Rex Trucking. Good to see you, brother. And Ike with the $5 super chat. Thanks for your coverage of this case, Megan. I read some of the case today, and all I heard in my head was your impression of Shapiro's ASMR voice. It's the best ASMR voice. Unhung Hero. Remember Reddit and both start with re. Yes, they do. Mike Dorado. Megan would be qualified if she was a man. Exactly. I like how they said Megan the journalist, and then it's like, but she's not really a journalist.
I know. Why did they say that? People are always doing that to me. I'm like, well, I have been getting paid for it for 20 years. Maybe you should tell my editor that I'm not a journalist because they've been paying me for a while now.
My bet most of these comments are Kurt Sock's accounts. Okay, thank you, Unhung Hero, for trying to shit stir. It ain't gonna work. Xcomer Triple Z, thank you so much. That's a great icon there. I mean, that's a great profile picture there. That is Meme Copium Josh under a waterfall in Japan.
No, stop it.
Yes,
that's funny.
That's him with his gunt hanging out there.
That's funny.
Your adeptness in navigating the intricate landscape of YouTube drama and engaging with emotionally charged individuals during live stream rivals that of a seasoned hostage negotiator.
I have to agree with this. This is true about Jeff. He's very good at it.
I just let people have their say, and if I agree, I'm like, yeah. If I'm not, I'm like, huh. And you move on. It's like, oh, well, thank you. I appreciate that. And then you move on. You know.
Yeah.
I'm friends with a lot of people that don't agree with me. I'm late. Did I miss much? Not a thing, Danielle Alexander.
We haven't even started.
And we're at exactly the 17-minute mark, which, as you know, if you follow any stream of Megan is mine, it always gets the comment. And literally, it's we did the Johnny Depp dramatic readings of the sidebars, and one of the comments was, "We've got to listen to 17 minutes of bullshit before they get down to what's going on."
Yes.
So you've had your 17 minutes of bullshit.
Every time.
Stingy, don't worry, Daddy Vices. We believe all you say. Don't believe all I say, because I'm just as wrong and most of the time as everybody else. All right, everybody, let's pick up at where we left off at page 93 of this motion. I can't even remember which of the claims we were up against here. Okay, we're starting medical negligence. We're starting the medical negligence claims. All right, hang on just one quick second here.
I forgot to tweet this out too, so I better go do that.
Oh yeah, I did too.
Oh no, I was going to your page to go retweet it, so it's not there. Well, how am I going to do it?
You figured it out. You're medium smart.
You didn't do it. You didn't put it up.
Forgot totally about it. Oh well. All right. Well, I'm not going to do it. You can do it. Everybody else, just tweet the hell out of this. Let's get people in here.
Look at Rob's super chat. So funny.
Wait, where'd we go?
Word on the street is the robot jury will need to sit for depositions. I wouldn't put it past them, Rob. I would not put it past them to call your jury.
Well, that's easily dealt with. My clients assert their right to remain silent.
Oh,
thank you so much for that, Rob. All right, medical negligence is the next claim. Now, if you'll recall, essentially what they're asking for on each and every claim is one, a directed verdict, a renewed motion for a directed verdict, where essentially they're saying, we know what the jury decided, but the jury was just wrong, and you know the jury was wrong just by the magnitude of the evidence in favor of our argument. So set aside the jury's verdict and just say we win. That's the first thing. If that doesn't work, then please give us a new trial, not only on the merits of the case, but also on the damages. And if you're not going to give us the new trial, then at least please reduce the amount of money we have to pay, because it's a lot. And you're taking money away from cancerous children. That's their arguments. So those are basically the three things they're asking for. Directed verdict in their favor, just say we win. The new trial for merits and damages, and last case scenario, the judge should just reset the damages. Let's look at the medical the medical negligence claims. We're only highlighting some certain parts of this because it's a long ass motion. This claim was that the failure to recognize CRPS as the definitive diagnosis and continue a treatment plan based on a continuation of the ketamine infusions, which Dr. Hanna had without dispute declared to have failed, was the basis of the claim for medical negligence. The following experts, in quotation marks, supported plaintiff's claim. And again, I have to reiterate this. We talk about it every time. The use of these like air quotes. Well, it's air quotes for me.
And
it's
italics.
Yeah, it's actual quotes for them. It's just air quotes for me. Italics,
But I mean, they are
exclamation
using
points.
it. They are using it as sarcastic quotes because they're not quoting anyone.
Yes.
So they're putting it. They're specifically using that is like a sarcastic air quote.
Yeah.
And Dr. Chopra, of all the people to claim he's not an expert, wow. I love Dr. Chopra. I thought he was fantastic.
And again, the hyperbolic language they use, all of these things, I think, as a lawyer, diminishes their argument. Again, it's what we talked about yesterday and what we talked about during the last motion regarding juror number 1. When you resort to using this hyperbolic language, this is the most outrageous thing. You can't conceive of any possibility of the mere suggestion that this might actually be a thing, or like they did to the dear elderly doctor. He hasn't practiced in this millennia. For God's sake, he's an elderly man who graduated from medical school in 1966 and, of all things, served in the Vietnam freaking war. That's how old this codger is, and he pretends to be. That kind of hyperbolic language just means they have a weak basis for a real argument. If you've got a strong argument, you don't need to appeal to emotion. You don't need to appeal to ageism or misogyny or misandry or whatever they're going into these things. You don't need to rely on these emotionally charged words. You can rely on the actual foundation of your argument. Yeah.
Try facts.
Yeah, facts.
Grounds. But they don't
so what's
have anything other than this hyperbolic language. That's
there's a lot of it. So anyway, so they're saying that the failure to recognize CPRS as the definitive diagnosis and continue the undisputedly failed ketamine infusions was the basis of the claim for medical negligence. The following experts supported plaintiff's claim. Dr. Pradeep Chopra is an adult anesthesiologist. Well, I'd hope. I don't want a child anesthesiologist doing anything like a Doogie Howser. I know. Anyway, it's an anesthesiologist for adults. Is an adult anesthesiologist with no hospital inpatient experience for over 2 decades. He opined the hospital staff misdiagnosed the child's condition and did not opine that the hospital should have used a ketamine infusion instead of the therapies provided. But Dr. Chopra failed to produce any evidence, as did every other plaintiff's expert, that any other hospital or any other institution in the U.S., much less Florida, would have been willing to continue Dr. Hanna's excessive ketamine infusion as he claimed would have been the case. So they're saying he's wrong because he didn't show any evidence that anyone else would have agreed with the treatment plan. Pure opinion. Florida law requires that a claimant shall have the burden of proving by the greater weight of evidence. That seems to be the 51% standard, that the alleged actions of the healthcare provider represented a underlined breach of the prevailing professional standard of care for the healthcare provider. The prevailing professional standard of care for a given healthcare provider shall be that level of care, skill, and treatment which, in light of all relevant surrounding circumstances, is recognized as acceptable and appropriate by reasonably prudent similar healthcare providers.
Well, you know what's interesting though about all of this is that Dr. Chopra is a specialist in a very rare and little known chronic disease. There aren't very many of him. So how many people is he supposed? Dr. Kirkpatrick is another one, and he agreed. So they're saying no one agreed, but that's not true.
But Megan, he has no hospital inpatient experience for over 2 decades.
Yeah, because hasn't he been teaching? I think it's because he's been teaching.
Oh, you mean they didn't put that in there?
I don't think so, but I think
yeah. There you go.
I think he's been teaching.
Well, Dr. Chopra,
professor. Yeah, he's a professor. So
he did not established by himself a breach of prevailing standard of health care providers similar to Johns Hopkins All Children's Hospital and the doctors who work for it in the hospital setting. So all by himself, his testimony alone didn't do this. Well, now let's turn to Dr. Eli Neuberger again, who they just savaged yesterday as just being this doddering old idiot.
The elderly
Yes.
child abuse. Oh my God, here we go again. By the way, the chat figured out that there's only a 6-year difference between him
Yes, I
and
saw that.
Altenburn.
And I'll tell you, who looks older?
Yeah, Dr. Neuberger looks pretty good, pretty spry.
Yeah, compared to Dr. Alter, Mr. Burns. Release the hounds. Smithers, bring me the child. Anyway, let's see what they had to say about dear old Dr. Neuberger. They savaged him earlier on in this
By the
motion.
way, hold on a second. I just found Dr. Chopra's resume.
Did you?
And yeah,
what
I
has he
did.
been doing for the last 2 decades?
So since 2005 to now, he's the assistant professor of medicine, clinical at Brown. He's at Brown, Department of Medicine, Division of Biology and Medicine. He also is the member of the Committee on Selected Heritable Connective Tissue Disorders and Disability, the National Academies of Sciences, Engineering and Medicine. He is also a member of the Medical Scientific Advisor Board, German Ehlers-Danlos Initiative, Germany. So those are the things he's doing. Oh, and also the honorary president of GERSED, which is something in German I can't read, but it has something to do with Ehlers-Danlos. It's an international group for research into EDS and its associated conditions. He's also on another medical advisory board for the Dysautonomia Support Network. So that's what he's been doing.
Okay, so basically he's been sitting on his ass doing nothing for the last 15 years.
He's teaching. He's an assistant professor.
Jeez. Yeah. It's like he hasn't done any clinical work whatsoever for the last 20 years. So therefore, he's not doing a damn thing and should not really be considered a real expert.
They're also wrong.
When he's doing all of this.
His professorship is a clinical one at Brown. It says right there in parentheses, clinical. So he is doing clinical work.
Don't read the bad parts out loud. Reddit doesn't like it. Reddit doesn't like it.
Reddit doesn't like it when we bring up the facts. Sorry, Reddit.
Well, now we are woefully unliked, Megan Fox. We have 1,270 people here and 385 likes. Literally 1,000 of you haven't hit the like button.
That's unacceptable.
Don't make Megan Fox mom shame you. Get down there. We need at least 1,000 likes in the next 30 seconds, or Megan will continue her feminine screeching at you until you do it. Just ask Reddit how much that. Yeah, just ask Reddit how much they like that.
The chat says that 1,000 are hate watching. Well, hit the down button then for all.
No, don't do that. Hit that like button, everybody. We need like 1,000 likes. We could easily do 1,000 likes here. We're entertaining. We provide you the information, but we kind of do it. We couch it in a little bit of humor, a little bit of lightheartedness, a little bit of sneedery, a little bit of snootery, a little bit of snottery.
Sneedery. Snarkiness. We have all the snarkiness you could possibly want here.
Yeah. All right.
Oh, and by the way, this thing did hit the docket this morning. I just needed to have refreshed.
Okay, there you go.
So
it is on the docket now, peeps. So Reddit, unbunch your knickers and just relax, get those panties out of a twist, and enjoy the motion. It's now open to all of you. And so hey, we've got 200 new likes. So continue going. We're like 400 away from getting to 1,000. So let's get to the 1,000 likes. And if you haven't subscribed,
proud of you.
We got a lot of subscribers over the past couple days. Thank you. Welcome here. This is us. This is what we do. We just finished a 2-hour Maritime Monday extravaganza about murder, mutiny, cannibalism, and court-martials from a shipwreck from 1741. Now we're doing the Maya case. Tomorrow we're going to be talking about the YNW Melly murders. We might be doing some Murdoch on Wednesday. Thursdays, an O.J. Simpson closing arguments review. This is what we do. We have fun here. We do things. We review things, and we talk about them in an engaging and entertaining way. So if you haven't hit the subscribe button, please do. I would deeply appreciate it. And make sure you get over to Megan Fox Writer, Megan Fox's channel, subscribe to her, and meganfox.locals.com for all of her updates and all of her news and all of her little personal bits. You see Megan's personal bits over there on Locals.
Jesus, Jeff, can you not talk about my personal bits?
I can't stop talking about them because I've seen them on Locals.
That is a lie. That is a damn lie.
Oh yeah, I know what your washing machine looks like.
This is true. Now that's true.
I've seen you fold laundry.
That is true.
All right.
There's a lot of it over there.
Let's see what they've done. Yes, well, disengage and get back to doing what you were doing, people. Let's see. Dr. Eli Neuberger is getting savaged again. They were brutal to this poor man. As I said earlier, they described him as having graduated from medical school in 1966 and being so old that he served in the Vietnam War. Well, what do they say about him here? Dr. Neuberger, the elderly child abuse pediatrician, discussed earlier, has not practiced clinical medicine during this millennium.
Oh, this is my DUI guy face. Oh, what a burn. What is wrong with them?
He hasn't practiced clinical medicine during this millennium. Like they literally worded this to make it seem like this old man has not practiced in 1,000 years. This is so stupid.
I need to know what vitamins he's taking, because if he's been around for 1,000 years, we all need to find out what is happening with Dr. Neuberger.
And this is what I was talking about, this hyperbolic language, really detracting from your arguments. You could say Dr. Eli Neuberger has been practicing for an incredible length of incredibly long period of time, such that he may not be aware of current developments or the latest in various technologies and treatments for certain illnesses. In fact, he hasn't maintained a clinical practice for at least the past 25 years.
Now, that would be far less offensive than this. It's like they asked someone to write this in the most offensive way they could possibly do it. And
right.
This is so bad.
When you see Dr. Eli Neuberger, this elderly person who has not practiced medicine during this millennium, it makes you laugh like we're doing. It makes you laugh at the way their argument is worded. And it takes you away from your arguments to where you stop and you go, what the hell was that?
It's very disrespectful. Very disrespectful.
Yeah, it's disrespectful, and you want someone to be engaged in your arguments. You want to pull them into your arguments. You want to hold them there. You want to captivate them and persuade them with your use of language. This makes you go, what? Dude, come on. It makes you do exactly the opposite of what you want your reader to do. If this was well written,
she's going to think about that sentence. Like, are you kidding me? Like, this is so rude. It's just so rude.
That's what I'm saying. I mean, these motions, the motion for a directed verdict, the motion for a new trial, the motion to reduce damages, the motion for remittitur, as they call it, these are very, very standard boilerplate, run-of-the-mill, everyday motions that anybody who loses a judgment like this would do just as a course of doing business in the lawsuit. This is a very standard thing they're doing, but it's the wording they're using. It's the arguments. It's the way they're going about it. If this was done in a highly professional, strictly legal manner, we probably wouldn't be here talking about this. But just the way they're wording it would be
too boring. It would be too boring to go through 144 pages of a well-worded argument. But it's not boring because they have put all this hyperbole in and these insults that are they're not even veiled. These aren't even veiled insults. They're not, you should ask Dr. Neuberger how to do an insult. That man knows how to insult you while sounding at the same time like he's reading a Jane Austen novel. It's incredible. But this is not that. This is just straight out insulting, just for no other reason than to insult.
And that's why when Megan sent this to me over the weekend, I was like 144 pages, and I looked at the table of contents and I went, oh my God, this sounds horrifically boring. And then I got to the statement that said, I think it was with Newberger.
It was about Beata, I think.
It was one of the witnesses. I think it was Newberger, where they were saying that he would have been a perfect witness
for Beata.
For Beata in the dependency hearing if she had chosen not to commit suicide and instead waited a couple of months to go to trial in February.
Hideous.
I read that and I'm like, what the fuck?
Hideous.
And I'm like, Megan, we got to find a time to do this, because that's what they literally said. They said he would have been a good witness for the dependency hearing if she had chosen not to commit suicide and instead gone to trial in February.
Yeah, this whole thing. When I saw it and I had scanned through it, I was like, I got to send this to Jeff. He has to look at this. And I'm like, Jeff, you must read this.
Yeah.
Like, it's too ridiculous for words, and also ragey. Makes me feel rage inside.
Yeah.
No, the docket does not have the hearing time on it yet. I don't know why, you guys. I don't know why. But there's nothing there for the hearing. There's appendixes that go along with this 144-page thing, and that's it.
So anyway, this poor doddering old elderly child abuse pediatrician who hasn't practiced medicine for 1,000 years. Dr. Newberger's testimony was couched in obviously inflammatory and argumentative language. You mean like not having practiced in this millennium and being elderly and... Ugh.
Yeah, who are they to tell somebody else that they have inflammatory and argumentative language?
Yeah, seriously. So what about Dr. Timothy Brewerton? He's a psychiatrist with an adult psychiatric certification. That does not qualify him to testify against a pediatric psychiatrist. He ain't good enough. He can only testify against adult psychiatrists.
I don't even remember him.
He testified primarily about his diagnosis that the family members currently suffer from PTSD and or depression. He testified that Maya Kowalski sustained PTSD from the events that occurred during her stay at the hospital, but did not testify that it was the events caused by the defendant as contrasted with the events brought on by the dependency hearings. His testimony was statutorily incompetent in any event because his adult psychiatric certification does not qualify him to testify against a pediatric psychiatrist. Well, the judge thought otherwise. Dr. John Wassenaar, the family physician, testified in sum that the pediatricians at Johns Hopkins All Children's were remiss in not calling him before considering the question of child abuse or Munchausen by proxy. Well, his opinions, if competent, did not relate to the diagnosis or treatment of CRPS. Dr. Tashana Duncan, a licensed psychologist. The court struck her testimony because she was not a licensed healthcare provider under Chapter 766. So in sum, the plaintiff deduced no competent testimony that a pediatric practitioner at Johns Hopkins All Children's Hospital deviated from the accepted standards of care concerning a diagnosis related to CRPS, or if that deviation were proven, that any doctor provided treatment that deviated from the prevailing professional standard of care for treatment of CRPS in a hospital, which was the standard of care required to be proven. So they're saying they basically didn't prove that anyone violated the standard of care.
But it sounds to me like their argument here is that they didn't prove she had CRPS, which is not the same thing as the standard of care.
Well, she was a licensed psychologist and school psychologist. It was never disclosed as a standard of care.
Standard of care expert.
Yeah.
Okay.
Yeah. And never gave a report pursuant to the court's pretrial orders and guidelines. She was permitted over objections to testify. It was eventually struck. So essentially what they're saying is all of the plaintiff's experts were too old, didn't practice, weren't qualified, sucked, and didn't know anything.
Okay. Got it.
And now, not only did all of their experts suck, were too old, hadn't practiced, weren't qualified, had their testimony stricken. Not only that, but the jury was too stupid to deal with things. The renewed motion for directed verdict on breach of duty. Even if the evidence was barely sufficient to go to the jury, the verdict is contrary to the manifest weight of the evidence. This is what we talked about yesterday, where it's like, okay, even though there may have been a little bit of evidence to support the jury's finding of liability, if you look at the manifest weight of all of the evidence, clearly it was more in favor of the hospital judge. So you have to set aside the verdict. You have to set aside the verdict and just give a directed verdict in our favor. We don't even need to go to trial. You know we're right. Just say we win. So that's what they're saying with this argument.
Yeah, we don't need to appeal. Jeff, check out what my locals made.
What did your locals made? Say one more time, mother. Do they speak English in palpable?
If you were watching part 1, you will know what this is about. But he used the word palpable at least 3 or 4 times, and I had to take shots. It was a very bad hangover morning for me after that.
And you're lucky you had to bail early, because there was more palpability. There was more palpability later on.
Oh my God.
Yeah. Say palpable one more time.
One more time.
Okay, so that they've said set this verdict aside and just rule in our favor because we win. And if that doesn't work, we need a renewed motion for a verdict on causation of damages. She was in the hospital for several months, not because the defendants insisted that she stay for treatment at facilities, but rather because the parties and the judge in the dependency proceeding never reached an agreement on a place to transfer her.
Yeah, you know why? Because Hunter was insisting that they transfer her thousands of miles away from her family instead of letting her guardian ad litem and the family's attorneys make the placement close to home, which is they were all in agreement that they were going to place her close to home, and Dad was going to stay at the Ronald McDonald House while he was dealing with whatever was going on there. But no, Hunter had to the hospital had to fight them and try to move her thousands of miles away to Cincinnati.
Yeah, they were talking like Cincinnati and was it Boston was one of the other places, or Detroit?
Boston Detroit, or somewhere far, far away.
Like Baltimore. Yeah, Baltimore.
Somewhere far away from Florida where they would have to, break up their family, basically. It was ridiculous.
Right. So that's their argument. They're saying, look, it wasn't our fault.
And it
was the family and the dependency proceedings.
Yeah, bullshit. Bullshit.
So accordingly, you have to rule in our favor at this time, because we had nothing to do with it. Nothing. Dr. Chopra testified under oath that the basis for his beliefs was facts, not belief. But no doctor with a basic understanding of the scientific method could state that honestly under oath.
Why not?
Because we don't say this is a fact in the scientific method, because that's just not the scientific method. We're always questioning. It's only a belief. We have to test our hypotheses. We have to test this. We have to keep questioning. We have to keep searching.
The science is settled, though, when it comes to things like the jab we're not allowed to talk about, and when it comes to other things, the science is settled. Yeah,
so they're just saying, look, he said that the basis for his beliefs were facts, not belief. But nobody with a basic understanding of scientific method would say that. Yeah, well, motion for new trial based on a verdict contrary to the manifest weight of the evidence. So again, this is like, okay, look, if you're not going to give us the directed verdict, just look. What's the wording here? The manifest weight of the evidence supports us, so we need a new trial. Even if CRPS were the one and only confirmed diagnosis of the child, an infusion with high dosage ketamine was well outside the prevailing professional standard of care. It appears to be the case that a small group of physicians treating patients on an outpatient basis, sometimes in the guise of an institute engaging in medical studies to determine appropriate treatment, did not provide treatment at least somewhat similar to Dr. Hanna's treatment. So basically what they're saying is this isn't a high dosage ketamine treatment is not a recognized treatment. It's human experimentation. They're getting all Dr. Mengele in this thing. That's essentially what they're saying.
They explained why that was, and it was because there isn't a big enough group of people who have CRPS to do a massive study. So they have to do these small studies. That's all they have. We already heard this, and that's very usual. It's not unusual when you have a rare disorder. You can't have a wide group of people to choose from to study it. That this is just common sense.
Yeah. Special KL Juror 1 has to sit for a deposition. We don't know. It's possible he could be called in for an interview by the judge, but Law and Lumber Rob is concerned that his robot jury may be called in for questioning as well. We'll have to see how that goes. I honestly literally wouldn't be surprised if that actually occurred.
That would break the internet. That would be so funny.
Yeah.
God.
Okay, Stingy. Okay, we already read that one. We already read Law and Lumber's. That's his robot jury will need to sit for depositions.
Can you imagine? It's bad enough they put a picture of it in the exhibits. Like, are you serious?
All right, incoming Foghorn, a group thanks for all of the super chats and other things that have come in during the past few minutes. We're going to read 10 of them here.
All right,
thank you so much. Go get some coffee. Thanks for covering this as Matt Bond. I've had CRPS for 16 years, PTSD from hospital doing the same shit, and my daughter being left from me. I've experienced it all. I'm sorry to hear that. That sounds. Oh, hang on. For some reason, we've just triggered Bixby on my phone. I've said some sort of words that it didn't want to hear. There we go. I'm sorry to hear that's happened. Just from what I've heard during this trial, it sounds like a horrific thing. And Crystal, the $1.99 super chat is Donna Adelson, Ethan's mom. Feels like it. You're not the first person to say that. And Hope Williams, thank you so much for the $10 sticker. And Matt Bond again, I'd enjoy a constipation bowel movement more. Yikes. That doesn't sound good at all. Ugh. And Cubber forever. Hollywood couldn't have scripted something better. This sounds like something straight out of Days of Our Lives. They are making it sound very, very soap opera-y, aren't they? Lacey Ann, thank you so much. They're really mad Neuberger switched from defense to plaintiff when he saw the evidence. I did not know that occurred. Wow. All right. I'm going to talk to Megan about that when she gets back. Vodka blood. Well, I've got gin tonic blood going tonight. I've told some family at Thanksgiving about this case. It's just so sad to even talk about, but such a serious matter. Yeah, absolutely. I mean, it is serious what's occurred. It's serious what's happened, and it's serious the way it's being handled by the defense. And T-Rex Trucking and more, thank you again. Any word on the hearing today? Time. So far, there hasn't been any update on the time. Will it be broadcasted through pool feed or just public Zoom? Again, we don't know that yet. I haven't seen it posted anywhere. Megan's been refreshing the court docket site and trying to find some more information while we do this. If we hear anything during the course of this, we will be sure to let you know. Thank you all for that. Let's get back into this, and we'll pick up where we left off. Thank you all, and thank you all here in chat. Flux says Lamau. Oh no, the Rees are here. Hey, the Rees are welcome. I love the dissenting opinions. I like to have people disagreeing. I like to have a robust discussion, as long as it's not just you're a dick and you're a bitch, that kind of stuff. And that's cheap. It's weak. It's lame. Let's have a good discussion. If you think it's wrong, if you think our opinions are wrong, if you think the defense is right, let's have a good discussion about it. A renewed motion for directed verdict, or in the alternative, motion for a new trial based on a verdict contrary to the manifest weight of the evidence concerning liability for Dr. Sally Smith. A motion for a new trial for legal errors that deprived the defendant of a fair trial. The court properly instructed the jury that defendant could only be liable for Dr. Sally Smith's actions as an apparent agent if plaintiffs were led to believe by the hospital that she was its agent, and then relied upon that belief in dealing with Dr. Smith as the hospital's agent. This is kind of an interesting one, and we'll talk about this as we go through. Assuming arguendo, so just for argument's sake, let's assume that Dr. Smith had possession, because they said that she was wearing a lab coat with a logo from the hospital on it. So they're saying, hey, welcome back, Megan.
Hey.
So they're
I
saying,
heard that thing you said about Newberger.
Yes.
I'm actually, I didn't hear about that. I do not know that. So if he was working for the defense, that would really be funny. That would be fantastic. I'll try and find out.
Well, that would be weird also, because it would be a conflict of interest at that point. So I'm curious.
You would think. Happen. So I've never heard that. So I'm skeptical if that's true. So.
Anywho, so assuming for the sake of argument that Dr. Smith had possession of and wore a lab coat with a logo for Johns Hopkins Hospital, as claimed by one of Mr. Anderson's other clients, her doing so was not the act of the hospital, but rather her own conduct. So they're saying that to prove this, you have to prove that it was the hospital that led the plaintiffs to believe that Smith was acting for them. They're saying it wasn't us, it was her. She got a hold of a lab coat somehow, if that even happened. Well, there's no evidence in the medical records of any treatment provided by Dr. Sally Smith.
That's not true. She had them remove her from her medicine. That's treatment.
Well, that is the argument. They had to remove him, and is taking someone off treatment considered to be treatment? I think it is.
I think it is. It's absolutely removing medication that is the same as prescribing medication.
You'd think, and so I don't really follow this argument that she didn't provide any medical treatment because of that. To me, saying okay, let's not take this medicine is in the course of a treatment. The medical information from Dr. Sally Smith available to the hospital staff was Dr. Smith's report that was prepared in December, and this court refused to admit that document into evidence under a 39 objection. This diagnosis was made in her capacity as the doctor in charge of the CPT investigation, for which the defendant is not responsible. Her quote-unquote diagnosis was for the CPT, not for the hospital. She wasn't acting for the hospital while this was going on. That simply was a concept too difficult for this jury to accept or understand.
Stop it. But see, this is what the jury decided. They decided she was working for the hospital. And that was within their purview to do. That this was part of the case. This was all about, was she or was she not, representing a de facto agent of the hospital. And the jury decided that she was.
Yeah, and they're saying the jury was so stupid that it couldn't understand that she wasn't.
Then you're too stupid, Shapiro. You're the one who's stupid because you didn't explain it then properly. Then you're the one that didn't make your case. You didn't persuade the jury to agree with you. That's your fault. That's Hunter's fault. That's not the jury's fault. It's your problem that you have with persuasion. You're bad at it.
Well, and when you're talking about, agency is a tricky thing. Because normally it's in I don't know exactly what Florida law is on this. I don't know the statutes, but generally speaking, it's how did the third party perceive this relationship? So how it would be, what did the family think of this relationship? Did they have a reasonable belief that she was acting as the agent of the hospital? And they're saying, well, she was wearing a white lab coat with the hospital logo on it.
That's evidence right there.
Said, that would seem to indicate that someone was working for the hospital and acting on behalf. She wasn't wearing a CPT investigation lab coat.
She also even admitted she introduced herself as part of the child protection team. She did not say, I am part of the child protection team with Suncoast that's contracted with DCF. She did not say that. She did not say, I'm working with the state. She just said, I'm with the CPT team. They're thinking that's something within Johns Hopkins. Anybody would.
Yeah, and Kuber for Ursa's agency is in the eye of the beholder. And see, I didn't see any evidence that the state, the hospital took any steps to disabuse them of the notion that Smith worked for them. To say, hey, whoever she doesn't work for us. She was cold or whatever, so we gave her a lab coat, or she took a lab coat. They didn't do anything to disabuse the family of their understanding that she was acting on behalf of the hospital. Rob was saying Juror 1 has to sit for a depo, huh? I thought, all right. Well, that's possible.
Well, how do we know this? Is there a hearing going on that we're not privy to?
Reddit, how come there's a hearing we don't know about? There you go.
Speaking of, locals made you a meme.
Oh, I'm sorry to hear that.
No, this is funny. You should.
It always is.
You should keep this one. There you go.
I like that one. That's good.
Uh-huh.
That's good. So I'm not persuaded particularly by this agency argument, because if she's wearing this lab coat, she's wearing a lab coat to the hospital, she's doing this diagnosis, she's doing the things she's doing, and the hospital is not going out of their way to mention that, hey, she doesn't work for us. She's not here. She has nothing to do with us. They're not separating her role from them. So it seems to me that it would be reasonable that anybody would think, okay, she actually works for the hospital. Again, I don't know the requirements of the standards under Florida law, but I'm speaking generally. But this diagnosis was made in her capacity as the doctor in charge of the CPT investigation. Nothing to do with the hospital. The hospital wasn't responsible for it, and the jury is just too effing stupid to understand this concept. That's literally what they just said there.
It's so insulting. That
simply was a concept too difficult for this jury to accept or understand.
Ridiculous.
That's insulting. That's just really insulting.
Mm-hmm.
Motion for new trial based on the legal error of allowing this case to contain a negligent training count to the very end, when that count should have been resolved no later than the motion for summary judgment. So they want a new trial because the judge didn't dismiss the negligent training thing. During Mr. Anderson's testimony, he made an accurate reference to the fact that Johns Hopkins All Children's Hospital had accreditation by the Joint Commission and CMS when this hospitalization occurred. So
you don't have it up on the screen.
Oh, wow. Trust me, that's what it says. Sorry, it was replaced by a meme. Blame locals.
Yeah, blame locals.
Cindy T, yes, just for you, I'll share the screen. Just for you, Cindy T. Not for anybody else. Because you have a little cat laying in the sun. That makes me happy. All right. Sorry about that, folks. Right. Okay, they had the accreditation. Mr. Anderson's brief testimony in this regard was in passing and hardly a focal point of his testimony. Their accreditation was hardly something to get all worked up about. Nevertheless, the reference became the occasion for permitting Dr. Corcoran to testify in rebuttal that 2 years later, defendant was in immediate jeopardy of losing its license. That's called opening the door.
Yep.
So they're saying, well, but we were accredited. Yes, but was it in jeopardy?
Why? Yeah, but how did that all happen? Is
right?
Question.
So they're saying, but their jeopardy in 2 years had nothing to do with what was going on back at the time. He claimed, without actual evidence, that immediate jeopardy status in 2019 somehow reflected on the hospital's culture during Maya Kowalski's much earlier admission.
Culture does not turn on and off like a light switch.
Yeah, and 2 years is not much earlier.
No.
When you're looking at a hospital's historical, cultural atmosphere, 2 years is the very end. Yeah. You'd
Yeah.
be looking at years and years, if not decades, of what has been the flow of the culture, what has been the structure in the hospital, what has been the working culture, what has been historically done. You're looking at that. You're not looking at
And
only the last 5 minutes.
you don't have an actual culture of retaliation and fear, and that get deleted and fixed in 2 years. Like it, no way, man. No way.
Don't try to rehabilitate that dumpster fire. Other dumpster fires, sure. What's the name of the Reddit group? Asks Mike Dorado. It's like
I don't know.
Maya's. I don't know. It's Maya
I
something.
really don't even know. It's like I took a
Reese.
screenshot of it. Like, do you really want to go there? It's a hive of scum and villainy. It's Take Care of Maya Free, FREE. But I mean, it's boring as hell. I wouldn't suggest reading it. It's boring as hell.
He claimed without actual evidence that immediate jeopardy status in 2019 somehow reflected on the hospital's culture during Maya Kowalski's much earlier admission. The admission of Dr. Corcoran's misleading testimony was completely unjustified and highly prejudicial. Taking place at the conclusion of this long trial, the prejudice was even more impactful. Well, then maybe you shouldn't have said the dumb shit you did when you said it.
Yeah. Maybe you should not have questioned Anderson over and over again about their accreditation and how wonderful and hunky-dory the hospital was.
And
You should have
everybody
stayed far away
historically
from
loved it, and they never had a bad report.
Should have stayed away from that, knowing that Dracula was buried. You should have left that buried. Who wrote this motion? I think it was Hunter.
Yeah, he's the one that signed off.
Signed it.
Yeah.
Yeah.
Well, then now they want a new trial, also based on legal errors in the admissibility of evidence from witnesses. And that's just basically in this section. In the section discussing errors that affected more than one claim, the defendant has discussed many legal errors involving the admission of testimony from witnesses without documentary evidence under the standards for a new trial for legal error. Oh, I'm echoing. What have you done?
I don't hear an echo.
Oh, I heard it for just a second.
Your ears.
Whatevs. Anyway, these errors entitled the defendant to a new trial. Now, what do we do about the damages? They want a new trial because there was too many damages awarded. The jury awarded $4.7 million in economic damages and $22 million in non-economic damages for this claim of medical negligence. So what are we looking at? $26.7 million. And they're saying they're duplicate claims, et cetera, et cetera. Scrolling down through all of this, they're just saying that was too much. That was just too much. For example, her future loss of earnings capacity in closing arguments was based on the theory of a total loss of income with a present value of $5 million for a young adult who was at the top of her class in high school and ready to attend an excellent college if motivated to do so. They're basically saying that was too much money. So what do you do about it? If you're not going to give them a new trial because they got too much money, well, then you need this motion for remittitur, which is, again, the motion just to reduce the amount of damages. So what do they want? Very last case, if you're not going to give a directed verdict, if you're not going to give a retrial on the merits and on the damages, just at least reduce the damages. Defendant submits from, what did we say it was, $26.7 million? Is that what we decided? Defendant submits the maximum lawful range for future economic damages from the alleged medical negligence would be less than $100,000. The medical treatment during the hospitalization actually caused little or no physical injury to Maya Kowalski in the hospital. So the future non-economic damages distinct from the awards for other claims should not exceed $500,000. So they're saying, yeah, Judge, you know that $26.7 million is too much. You should just award $600,000. That's their argument. We're not going to talk about the billing fraud because, frankly, it's boring and kind of.
I'm being told that they filed a supplemental motion that has to be read, but I'm not seeing it. Oh, hold on. I have it now. Hold on. I have it.
Oh, fuck. Of course you do.
I have it.
Why? How long is it? It's going to be another 50 pages.
It is only 5 pages.
Oh, all right. Well, cool. We can do that. So
And
let's
it's all
barrel.
about juror. It's all about juror number 1 again.
Oh, of course it is.
Oh
Great.
yeah, it's only 5 pages. I will send
All
it
right.
to you. Okay, just
Alrighty.
Yeah.
So we're doing pretty good. We only got 20 pages. There's 24 pages left here, and there's not a lot to talk about on those 24 pages. Let's see here. Motion for neutral. We're not talking about all of these issues affecting the claim. Okay. Right. Now we're getting into the claims by the estate of Beata Kowalski. These are the claims arising from their causing her to self-delete. We're still too early to actually say the S word. But I don't care.
what's the S word?
Suicide.
Oh, that word. You didn't have to say it.
I don't care. I'm not about the monetization for this.
Yeah.
We've got some generous super chats to keep us going. So hey, if they want to demonetize us for that,
I
YouTube
never
is
have
asshole.
any of my live streams monetized. I'm always terrified to turn the thing on, so I just leave it off.
So issues affecting the claims presented by the estate of Beata Kowalski. The jury returned awards for both the survival claim and the wrongful death claim based on intentional infliction of emotional distress. The estate must make an election before entry of any judgment. Intentional infliction of emotional distress seeking survival damages. What evidence is there that some employee committed an extreme and outrageous act beyond all possible bounds of decency, atrocious conduct, utterly intolerable in a civilized community, and did so with the intent to cause Beata Kowalski severe emotional distress or with reckless disregard of the high probability of causing that severe stress? Perhaps this unidentified person who threatened to have the Kowalskis arrested if they removed Maya Kowalski from the emergency room or the intensive care unit? Well, Beata Kowalski's own email admits that at least later she no longer wanted to remove the child in this fashion. So they're saying that, hey, in her email says she didn't want the child removed. So where's the stress?
Well, but that's because they were being threatened with police action if they were to remove her.
Well, assuming that Beata Kowalski was merely strong-willed and very persistent in those encounters, where is the evidence that an employee of Johns Hopkins All Children's Hospital responded with extreme and outrageous conduct? Was calling a doctor known to be a child abuse expert to obtain advice from her actually an act that a civilized community would not tolerate? The truth is there's no credible evidence of any extreme or outrageous conduct by the defendant's employees in that period when Beata Kowalski was allowed by law to enter the hospital. Well, could be that the extreme action was not allowing her to enter the hospital, but then they're going to say that was because of the dependency stuff.
Yeah, but there was 7 days where they were keeping her from taking her kid out. And during that 7 days, they were also threatening her with police. I think that's extreme and outrageous, especially when you don't have a court order to do so. So sorry, but no, different people see it different ways, guys. And I don't agree with this at all.
And it'll be up to the judge to decide. But missing such evidence, the plaintiff has resorted to a great conspiracy based at very best on speculation and the stacking of the thinnest pieces of circumstantial evidence. Because the doctors were threatened or intimidated by this strong woman, and perhaps because she planned to make some complaint to someone about their treatment of her daughter, the doctors entered into a conspiracy to destroy Beata Kowalski. Now, if you can't pick up on this, they're being sarcastic. They're poo-pooing and laughing off and mocking this grand conspiracy that they're alleging she had to have come up with. So they perhaps she was going to make a complaint against the hospital, so they entered in this conspiracy to destroy the hospital. Entered into this conspiracy to destroy her because she was going to make a complaint. Because Beata Kowalski was no longer in the hospital, this conspiracy required the creativity necessary to construct a plan akin to a Mission Impossible.
Oh, this is so dumb. You know what? It doesn't need to be any more conspiratorial than this. The hospital knew they had a liability issue. Risk management got worried, and they decided to tie the family up with Child Protective Services instead of having to get tied up by their lawyers, period. That's not a conspiracy theory. It happens every day. Happens every day in hospitals. So
Brittany gives us, they did. Thanks for laying that out so nicely for us, Defense.
It doesn't look, those of you from the Reddit page who are here in the chat, this is their only argument. The mom and the family are crazy. Like, that's their only argument. I'm sorry, guys, but you're going to have to come up with better facts than that. You're going to have to come up with evidence of that. We didn't see any evidence of that. In fact, Maya Kowalski's psychological profile that was done of her for the dependency court came back completely normal. So she is legitimately not crazy. She was not crazy. Yeah, they did this to shut her up, make her go away, intimidate her so that they would not have a case against the hospital. They'd be too busy fighting in the dependency court.
And Lat Cali Girl number one, this is the defense's motion that we're reading now. This is the defense motion for a new trial. They want do-overs. So because, see, and again, it's this hyperbolic, derogatory, degrading, sarcastic, mocking language that lawyers are using in their brief to other lawyers and to a judge. It's uncalled for language. And if the plaintiffs were putting this kind of language in their motions and I noticed it or it was brought to my attention, I would call them out on it as well. Mm-hmm. Because I think it's unnecessary and unprofessional. Mm-hmm. This conspiracy required the creativity necessary to construct a plan akin to a Mission Impossible episode. The doctors who would have limited contact with Maya Kowalski once she was on the 7th floor would convince the staff and Ms. Beatty to treat Maya Kowalski very badly. This would cause the girl to tell her father and maybe her brother and other friends about this terrible treatment. They would then go back to the Sarasota County and tell Beata Kowalski these stories in a manner so extreme that it would cause Beata Kowalski to suffer from severe emotional stress. With the perfect execution of this plan,
they could just be what was happening, and that would cause her extreme stress. They dropped her daughter. They roughly transferred her. They locked her in a room. They stripped her of her clothes. None of that needs to be exaggerated in order to be severely distressful to a mother. Sorry, continue.
You interrupted the flow as I was building up to the final sentence. I was building up to the final sentence.
I'm sorry. It's too stupid, though.
And now the final sentence falls flat. With the perfect execution of this plan, the doctor's revenge would be complete. If this version of a claim of intentional infliction of emotional distress presents a jury issue under the law of Florida, the law has gone way too far. Well, tell you what, if the law has gone way too far, you better find a way to change it, if that's your opinion. Like, that's just your opinion, man.
Yep.
Yeah, well, that's just like your opinion, man.
I need that.
The hospital put her daughter in a room with a video camera to test. See, this is the bullshit part of I hate this every time this sentence comes up, and it comes up several times in this motion. The hospital put her daughter in a room with a video camera to test to see whether her behavior was consistent with CRPS. No, they didn't. By their own admission, they put the camera in there to prove she didn't have it.
And that's not treatment by any stretch of the imagination. That is not treatment of an illness. That is trying to catch, not believing your patient. It's trying to set them up. It's setting a trap. It's investigation. They were acting like police instead of acting like doctors, and they absolutely should be struck for that. They should be absolutely caned in the public square, Singapore style, for that, period.
And that was literally the words they used in their communications to each other, so that we can catch her.
Yep.
Not so that we can observe her behavior to determine whether she exhibits symptoms consistent or inconsistent with CRPS. They said they're doing this so they can catch her.
Yep. That's not medical care. That's police behavior. That's a sting operation.
Well, and it flies in the face of this statement. that they put the daughter in the room to see whether her behavior is consistent with CRPS. That's a bullshit statement. Perhaps the hospital should have trusted her enough to tell her or obtain her permission. It's okay. Yeah, they're saying, well, maybe we should have told them we're doing this. Surely a mother who believed her daughter had CRPS would agree to a video running in the room for 2 days, hoping to confirm a conclusive diagnosis of CRPS.
That's not how you confirm CRPS. That's not how it's done. Did Dr. Chopra ever say that to diagnose someone with CRPS, you have to lock them in a room for 48 hours and videotape them surreptitiously? That's not part of the diagnosis. That's not part of how the diagnostics works for CRPS. They're full of absolute crap.
And again, it's beating a dead horse at this point. I'm not going to reiterate what you just said because you yelled it effectively enough.
Sorry, are your eardrums okay?
They're perfectly fine. I just don't need to damage our good listeners' ears anymore with my own similar rant.
I'm sorry. Is my volume too high?
No, you're
Chat's
perfectly
complaining.
fine.
You do have to know. I'll try and back up if I'm going to scream again. I'm sorry.
And very jokingly, it's because she's a woman and that's what they do.
It's true.
Clearly, you guys have never been married.
He's not wrong.
No. It's either this whole deal. Perhaps the hospital should have trusted her enough. This may be a different conversation if they had said, this is what we want to do to see how she exhibits, to see how she manifests. Maybe this would be different if you had actually done that. But you didn't tell the mother, you didn't tell the father, you didn't tell anybody. You just did it and then covered your ass later. And now the way I see it, the defense is wholeheartedly rewriting the story. They're doing some retcon of history here. So, oh no, we were doing it to confirm whether it was consistent with it, when they clearly said they were trying to catch her. All right, I said I wasn't going to scream. Let's move on. The hospital arranged for 2 female employees to place Maya Kowalski on a bed in a hospital room in her shorts and bra to photograph her on January 6, 2017. Maybe that would be enough to upset Beata Kowalski, except for the fact she never knew about that event.
Oh my God.
She couldn't have been upset about that because she never knew about it. The camera with its images was back in storage at the hospital when Beata Kowalski wrote her suicide note after a very stressful experience in court.
Are you telling me that nobody could have told her about it?
That's what they seem to be implying.
How do they know that? How do they know that? The hospital.
That's what they seem to be implying.
They wouldn't know whether Jack told her or not. And also, what does it matter that the camera was in storage? The family didn't get to see the pictures. I don't think they heard about this from Maya. So it's not like Maya had the pictures and was able to forward them. The camera being in storage has absolutely nothing to do with it.
Notice.
I wonder what other images are on that camera, by the way.
Notice how they twist this at the end to make the suicide note the fault of the court. When Beata Kowalski wrote her suicide note after a very stressful experience in court.
Mm-hmm.
It's not our fault. She had a bad day in court. So,
and the reason she had that bad day in court was because Howard Hunter was convincing the judge to send her daughter 3,000 miles away, 2,000 miles away. Howard Hunter, the hospital's attorney, was doing that.
Beata Kowalski could be totally justified in experiencing extreme emotional distress because her daughter could not come home. Because her daughter was upset she could not come home. Because they could not be together for Thanksgiving, Christmas, and New Year's Day. She could be totally justified in experiencing this extreme emotional distress because she would have to go to trial and risk losing her nursing license to get her daughter back. But all of that was wholly the result of DCF's dependency proceedings. Not our fault. It's now quite apparent that the jury simply was unable to sort out what stress was attributable to this defendant. The jury's too fucking stupid.
Yep.
to realize that this was all the court and the DCF fault, not ours. We had nothing to do with it. We didn't give them a lick of stress for anything.
I am shocked and dismayed that they let Howard Hunter be the lawyer in the dependency hearings and also the lawyer on this case. Because of that, he has taken that opportunity, knowing the jury can't know anything about the dependency case, to lie in his filings about what he did and did not do, what the hospital did and did not do. I am shocked they allowed him on this case, because why would he put himself in that position where he is lying in these motions about what was going on in the dependency case when he knew damn well what he was doing? He knew damn well whose fault it was. It just pisses me off.
Well, it's not their fault. That's what they're saying. It's not their fault. You know, it's all everybody. It's all, you know, the court and the DCF's fault. They're the ones that did it. They were the ones giving the stress. After Maya Kowalski's death, one of the hospital employees used her cell phone to email another employee to say that she had predicted this. Well, yes, they did. Well, so what's the problem here? According to the defense, that plainly was not an act that created stress on Maya Kowalski after her death. It's a fucking stupid thing to say, isn't it?
Mm-hmm.
That note that text saying they predicted her death, it couldn't have caused her stress because she's already killed herself. Why that sentence does not need to be in there. Anyway, this court has stated that this evidence is highly relevant, but what does it prove? Is it the key to the grand conspiracy? The doctor, yes. The doctor explained why she said this in a personal text message to another doctor. She had been aware of another parent's suicide many years before when she was a resident.
So they've done this before. It's like a thing they do.
Well, that's one thing. That sort of opens that door to, oh, so this has happened before. And also, she knew the likely outcome of giving this stress to the mother. Yep. She knew that what they were doing could possibly cause her mother to do this in a similar situation.
And she said it was going to happen. She predicted that it would happen. And there was also another note, which I noticed, I don't think they talk about in this filing. Another nurse or doctor said that Beata told her personally she wanted to die. And that person did not call 911. That person did not help her in any way. So there's two instances here of doctors or nurses or whatever at JHACH knowing there could be this problem and not doing anything about it.
Well, perhaps the email is some evidence that some employees had some reason to believe that they should be careful in their direct dealing with Maya Kowalski. Except they had no further direct dealings with her.
Yeah, because they banned her from the hospital and then didn't let her have her visitation. Yeah.
Respectfully, the email is more prejudicial than probative, and it does nothing to prove a claim of intentional infliction of emotional distress. So, because it was clearly not our fault, and because the fact that they knew this had happened before and was likely to happen again, it's not our fault, and it's prejudicial, we're renewing our motion for a directed verdict. And then they say, if you don't give us the directed verdict, which again is just to simply say they were wrong, we were right, just throw out the verdict and rule in our favor and call it a day. If they're not going to do that, we want a motion for a new trial on a verdict against the manifest weight of the evidence. There's no question that Maya Kowalski was experiencing severe stress due to the charge of medical child abuse in the dependency court. That charge had taken her child from her for a long time. If that case went to trial in February and she lost, not only would she risk having her child in foster care, but she also risked losing her license as a nurse. But none of that is stress for which this defendant is legally liable. That's their argument. And I will say, amongst all of the arguments they're making, I think this intentional infliction of emotional stress distress to cause Maya's mother's suicide. I think this is among the weakest of the prosecution's case.
Mhm.
But the jury is the finder of fact. The jury made their decision. Is there enough to get a new trial or a reduced verdict? That's going to be up to the judge. I don't think this is the strongest argument the defense has. I mean, this isn't the strongest argument that the plaintiffs have. So I think amongst everything we've read, this is probably the weaker of the arguments. But that we don't know how it'll turn out. But $3 million. They want a new trial because that's just way too much money. $3 million for non-economic damages for whatever period might exist between the point when the extreme and outrageous conduct caused severe emotional distress until Maya Kowalski's death is far beyond the range in which the jury is free to operate. Whatever pain and suffering she was experiencing in her own silence during the fall due to everything that was happening, this defendant should not be required to pay $3 million. Like, that's just your opinion, man. Intentional infliction of emotional distress caused death by suicide. Same arguments, basically. She had an ongoing concern. This is what matters were known to her about any extreme and outrageous conduct of the defendant's employees over that period. She learned of the video recording made in October by mid-November. She had an ongoing concern about the defendants continuing to use Ms. Beatty as the social worker. But at worst, that action by the defendant was a negligent act of supervising or training. There is no credible evidence that the defendant kept this experienced social worker on the case intentionally to cause severe emotional distress to Maya Kowalski. As a matter of law, it is inconceivable. You keep using that word.
Wait.
Yes.
Before we get to this, I was just thinking about that thing about Kathy Beatty.
Yeah.
While it may be true that they didn't keep her on to specifically hurt Maya Kowalski, they did not do any review of this case that would have found this person was causing undue stress and undue burden on the family. They definitely didn't do any review. They had no risk management oversight. They had no, you heard, none of the people, and none of them even heard about it. Dr. Perno was like, we didn't even know until the news reports came out. So they were not, just like Dr. Corcoran said, they did not have a system in place that would catch these things before it got to this point where it's out of control. So, and that was the argument that the plaintiff made. The plaintiff wasn't making the argument that the hospital specifically put Kathy Beatty on this case because they knew that she would drive this woman to off herself. No, the point was they had nothing in place to make sure that these things did not happen, and they weren't checking up on it, and they weren't listening to Maya, and they weren't following up. And so because of that, Beatty was allowed to continue her child abuse unchecked.
Well, and I mean, the question is, I mean, this is, the hospital, they said we didn't put her there specifically to cause emotional distress. But as someone who worked for the hospital, was she doing something to intentionally cause stress to Beata for
and
whatever
also,
reason?
They should have known that she was not a good person to have on this case based on her record at the hospital with her previous incidences where she was like, catch me outside girl, so she got into like several altercations with people that she worked with. She had a criminal record for an arrest for child abuse. She should never have been hired in this hospital in the first place to work with children. My God. I can't even believe I have to say that sentence out loud. Oh, she was arrested for child abuse and yet still works with children. Okay.
As a matter of law, it is inconceivable that conduct in October could be treated as the legal trigger for this suicide in January. But what stress legally attributable to the defense caused by extreme and outrageous conduct occurred, even that would warrant a person to commit suicide? Well, Maya Kowalski did not commit an impulsive suicide in the span of a few minutes or even a span of hours. She wrote suicide notes on Friday and presumably committed suicide on Saturday afternoon or even early Sunday morning. She did not rashly grab a knife or a gun to kill herself. She carefully executed a plan for suicide based on her expertise as a nurse infusionist. And she did this without any direct involvement or encouragement from the hospital. She did it without her family or Dr. Duncan foreseeing her suicide. But this court has decided that Florida law now makes her suicide 100% the responsibility of this defendant under the facts of this case. And of course, the jury once more demonstrated that it was acting on prejudice and passion when it awarded more than $100 million for this death. If the court does not grant relief on this claim, no rational hospital administrator will be willing to keep a child in DCF custody for any period beyond the point where the child is eligible for discharge to medical foster care. And again, why would you want to do that in the first place? If someone's ready to go and eligible to go somewhere, why not let them go? Many families who cannot accept that their loved ones committed suicide will believe that they can sue someone with indirect connections to the stress involved in their loved one's life. So the family just brought because they just can't accept the suicide. So they want to blame the hospital for it.
Well, who the hell could accept it anyway? But I can't even with these people. Like this is stupid. This whole thing is stupid. Maybe they should behave better. Maybe they should treat their patients better. I don't know. Maybe they should stop. Maybe they should fire the 7th floor coven and get some nurses in there who care about patients.
So that they go through the same things they've argued for every other claim. They say they want a directed verdict, and if that doesn't work, they want a new trial based on the manifest weight of the evidence being in their favor. They want a motion for a new trial based on legal errors in the jury instructions and on the decision to add a second theory of causation in the middle of the trial. They want a motion for a new trial based on errors related to the testimony of Dr. Richards. Dr. Richards is a psychiatrist who was on the swim team with plaintiff's counsel in college. Again, just have to dismiss that because they were on a swim team together. He never performed a psychiatric assessment of Maya Kowalski during her lifetime.
They really had a problem with him having friends testify.
Yeah.
Because Greg has a lot of like really professional, good friends who are qualified, and like they don't like the fact that Greg's got all these friends who will do this shit for free.
For free, exactly, yeah. He never provided treatment for her. In fact, he never saw Maya Kowalski during her lifetime. He claims to have evaluated more than 12,000 patients for risk of suicide during his career. Okay, so somehow that makes him unqualified, I guess. He created on the stand what would sound like a scientific test for irresistible impulse for the jury, an impulse involving altruistic thoughts. This test is neither science nor the law. The defendant objected to Dr. Richards' testimony in its entirety and to his ability to render his opinions, but this court allowed his full testimony. Although the defendant convinced the court to at least change the legal phrase to uncontrollable impulse after Dr. Richards transformed the legal test of irresistible impulse into a pseudo-scientific concept. The plaintiff's closing argument simply equated Dr. Richards' irresistible impulse with both uncontrollable impulse and substantial factor.
Well, you agreed to it. The defense wanted that. They got it. Now they're complaining about it.
And they're asking the judge to say that the judge was wrong in his decision. So
I'm sure
not a lot of chance. Yeah. So the total award for this was $108,653,676. But they still managed. They said there was, they did all this stuff. They still managed to give Mr. Kowalski $68 million instead of the much lower but excessive number on the PowerPoint argument.
But excessive, much lower, but also excessive. We don't want to give any money. Yeah. No money at all.
Oh, no, they don't. They awarded each child $20 million, $2 million each for the economic loss of support and services, which the PowerPoint incorrectly described as the non-economic loss of companionship. They awarded an additional non-economic award of $18 million. The defendant is simply being punished with unauthorized punitive damages for a wrongful death in which they, quote, killed Maya Kowalski by extreme and outrageous conduct that is nowhere supported by the evidence.
Yeah, that's just your opinion, man.
Yep.
Our opinion is different.
and the motion for reducing the excessive compensatory damages. As to the net accumulation for Beata's estate, if she could have saved the equivalent of $20,000 per year in current dollars over and above her annual expenses until she retired after 25 years, the present value of that amount would be approximately $500,000. But ignoring most of the expenditures, $400,000 is the present value of net accumulations available in her estate to bequeath to her heirs would be a very high award. The defendant submits that this is interesting. They admit to $6 million. The defendant submits that the highest award under an order of remitter should not exceed $6 million. So even then, I mean, it's a lot less than the hundred and however many tens of millions were awarded. But still, getting them to say $6 million is a big thing, considering that they're asking for 0 or 100,000 for this or 25,000 for that. That's kind of a big admission there. In conclusion, the defendant realizes that this is a long set of motions, but factually there are 10 overlapping claims including the 3 false imprisonment claims, the 2 battery claims, the 2 claims for intentional infliction by the estate, including punitive damages. The entire verdict exceeds $260 million. These motions address a verdict for $250 million for claims that each raise serious questions about whether they even should have been submitted to the jury. They address what appears to be the first ever trial of intentional infliction of emotional distress causing a suicide. And it is a claim by the estate of a woman who had not been at the hospital for almost 3 months, was never a patient, and had almost exclusively indirect contact with the hospital employees. A case where the suicide occurred after events in a court proceeding with which the state and DCF are protected by sovereign immunity. These motions have merit, they warrant full consideration. Respectfully, it's Chris W. Altenburn. Okay, there we go. It was Altenburn that did.
He wrote this motion with all that crap in it about the
being old. Yes.
Wow. I'll be right back. My camera's acting up.
Oh no. NCS Hunter. So there we go. The certificate of service was signed by Hunter. Yeah. Altenburn, who's 6 years younger than the doctor, was calling him old. All right, Megan's back.
Wow.
Hi.
Wow. I can't believe Altenburn was the one calling Neuberger old. Wow.
Now, I guess the big takeaway from that for me is kind of what they concluded on. I think the weakest argument is the intentional infliction of emotional distress causing the suicide. I mean, that's a gigantic chunk of change that they were awarded in that claim. And I think there's I don't know. I'm just going to randomly say a coin. I would never. I mean, it's so hard to say. There's this much of a coin's toss. I just don't know, because it's literally maybe the first time this argument's ever been.
It is the first time it's ever been succeeded in civil court, not criminal court, but in civil court. However, I will say the facts of this case, if they can't get it in this case, there will never be another one again that they can. I think the facts are good for that charge, and we'll see what happens. But I sent you the 5-page thing about the juror number 1. Now, you guys, this is going to make you really angry. They are now defaming this man. They have dug up a 20-year-old charge.
Oh dear. Oh wait. Oh, come on. Let's just read it. Don't give us any spoilers. Right. Let's just read it. All right.
I just want to say before we read it, I want to just say that anything that happens during a divorce in custody trial should be looked at with much skepticism, and juror number 1 deserves our belief of his innocence, because people will say.
Let's read it and talk about it. I think we should read it and talk about it. You're ahead of the game here. I'm pulling it. I'm just waiting to pull it up right now.
I have qualms about reading it in the first place because it's so full of garbage. It's so full of allegations with no evidence. It's upsetting. I would hate this to happen to my family. Again, this is jury intimidation is what this is.
Well, let's poke around here a bit and see.
And I have other ones to send to you too. There's exhibits, so I'll be sending those to you one at a time.
Okay. supplement to and this is first time I'm seeing this. Supplement to defendant's motion for new trial based on juror misconduct. Motion for juror interview. Motion to open discovery into evidence of juror misconduct, and emergency motion to preserve evidence. Okay, so that's the title of the motion they gave the other day, and this is the supplemental to it. So before we get to that, Brian Miller with $4.99. Reddit users are the same people in Lawn Cuck chat.
Probably.
We need to give everybody the big foghorn here too. Thank you for your support. Special KL Rob was saying juror number 1 has to sit for a depo. Okay, I haven't seen that. Maybe it's in here somewhere. Maybe it's in an order somewhere. I'm not.
I've seen an order. I've seen a request for it, but I have not seen it granted or anything. So I don't know.
And Snelson 134 says, and all they will do is reword their future documents to correct your semantics. Probably should have read that before. That was like, just reword their future documents to correct your semantics.
It is also possible that juror number 1 told Rob that, because I know, he's been
could be. Oh yeah, that could be.
It's possible that came from the juror. I don't know though.
And Enchiladas Unbreaded, open contempt for plaintiffs, plaintiffs' attorneys, plaintiffs' experts, jury, judge, decorum, and common decency. Wow, bad lawyering. It's not. I don't know if it's bad lawyering. It's just not the kind of lawyering that I would want to do, and I would want to be associated with. I would want to be able to look in the mirror and just at least pass the mirror test. Mike Dorado, thank you so much for being a new member. Deeply, deeply appreciate that. Well, let's see this. And if it gets too gory, we may just pull the ripcord. Defendant Johns Hopkins All Children's Hospital, by and through undersigned counsel pursuant to this, it makes this supplemental motion. Supplemental factual background. Since filing the above referenced motion, defendant has discovered additional material evidence of potential juror bias and misconduct is set forth herein. Specifically, defendant has discovered from the website of the Clerk of Courts of Broward County, Florida, the juror number 1 was the respondent in a domestic violence case. Oh, for fuck off sakes.
Yeah, here we go.
In a domestic violence case against him by a former spouse that involved a sworn notice of allegations of child abuse. The content of the underlying filings are not available to defendant for review. However, given the allegations of child abuse, it's reasonable to assume that the Department of Children's and Families, a key player in the present case, may have been involved in the domestic violence proceeding.
Or maybe not at all, because it could have just been dismissed immediately based on whatever it was.
A notice that some allegations of possible child abuse happened. We don't know what it said. We don't know what's going on. It might possibly have involved a DCF.
Well, we don't know.
Yeah.
Because we didn't do the underlying work. We didn't get the records. We don't know. So we're just gonna slander this guy and open up his total history. 20 years ago, by the way, it was filed. 20 years ago.
Defendant submits that juror number 1 should have disclosed this information on the supplemental jury questionnaire during voir dire or during trial when his potential bias was called into question by evidence presented in the case without regard to his innocence or guilt. Well, which was it? You're going to mention that? It is reasonable to assume that juror number 1 may have harbored ill feelings towards the DCF, or at a minimum, an allegiance in favor of a party accused of suspected child abuse, like the late Beata Kowalski.
You know what they didn't? Look what they didn't include. They did not include the question on the questionnaire.
Yeah, that's what I was asking. What was the question?
That he would have had to answer yes or no to. Did they even ask? I don't know. I haven't read this yet. Maybe we'll get to it.
Yeah. Under the circumstances, the existence of this information and juror number 1's failure to disclose it corroborates defendant's reasonable belief that juror number 1 was inherently biased against DCF and the defendant. Well, okay, so say they're biased against DCF. Is this a lawsuit against DCF?
No.
That's what I thought.
They weren't a defendant in this case. No. In fact, they have immunity through Chapter 39. So they're not a party to the case.
and harbored an allegiance with Mrs. Kowalski and plaintiffs, resulting in a verdict motivated by emotion and extra record evidence rather than an objective evaluation of facts. I don't know where this is going, but this was not a jury of one person.
No.
This was a jury of 6 people. And that's how they're trying to couch it. This was 6 independent people that arrived at the same decision that the hospital should be liable. But they're trying to say that juror number 1 was the leader. He was the controller of the group. He was the guider. He was the director. He was the mastermind behind this. They all just fell in behind him, lock and step. That's why they've always been saying under the leadership of juror number 1, so that they can say, look, he's got this bias, and as a leader of the group, he bent everyone to his will or some shit like that. They're not treating.
He's a mega Chad, apparently. Juror number 1 cannot be denied. He just leads people. Everyone does what he says, even his wife. His wife always does what he says and doesn't. She only, believes what he tells her to believe. It's incredible. This man has powers. He should start one of those Andrew Tate self-help things, because apparently he can just gather the troops. This guy.
And they polled the jury and asked each one of them if this was their own personal verdict. Was this their own personal judgment? Yeah, and they all said yes. So yeah, this is interesting that they're doing. They're treating him as a jury of 1, while there was 5 other people that came to the same conclusion. Moreover, juror number, before we get going, we got a massive super chat here from Tank Rat. You get your own foghorn. Oops, you get the big foghorn. Tank Rat says, well, I've been listening while working. Now I can sit down, but still need to do the paperwork and database entry. So more listening. Well, thank you for your generous support and super chats with not only the super chats, but the memberships you constantly are giving people. Thank you so much for being such a huge supporter of the channel, Tank Rat. You're a fine human being. Deeply, deeply appreciated. Moreover, juror number 1.
So exhausted. Moreover,
juror number 1 suspected hostility towards defendant and suspected. Prove it, bitch. Prove it. Don't say suspected. You don't get something for suspect. See, they're saying suspected, possible, all this, so that they can bring him in for an interview to engage in a fishing expedition to find more.
Right.
They're not coming with. I mean, they can literally. It's the spaghetti argument here. They're just throwing everything in the wall and saying what sticks. Defendant and defense counsel and bias in plaintiff's favor has been further corroborated by his continued post-verdict social media posts. He can say whatever the flippin' F he wants after the verdict.
Yeah, how dare he continue to use his First Amendment rights that he's entitled to use?
Now, he was here yesterday. God damn it! If I show up in this motion, I'm going to be pissed.
I know, right? Me too. I'm trying hard to stay out of them.
More recently, on November 23rd, 2023, juror number 1 posted a statement on the pro-plaintiffs Facebook group, Take Care of Maya, named after the sensationalized documentary strategically released on the heels of trial. Juror number 1 claimed unfamiliarity with in his juror questionnaire. In direct opposition to defendant's motion for a new trial based on juror misconduct, etc. See Exhibit B in this post. Juror number 1 referred to his perceived legal and constitutional freedom of speech. His perceived.
No. That's his guaranteed, not perceived, but his guaranteed legal and constitutional freedom of speech. You absolute assholes. What is wrong? These people graduated law school? What law school?
Well,
was it in Samoa? I don't understand.
Well, let's see how the sentence ends. See if somehow they saved themselves. His perceived legal and constitutional freedom of speech as a service as a juror without restraint, inappropriately accusing defense counsel Howard Hunter of tyranny and being immoral
He is immoral. He has shown himself to be very immoral. That is a perfectly protected opinion. That is a perfectly protected opinion, to have an opinion that some slimeball attorney is immoral. You have a right to say it. I don't care if you just ruled against him. The trial is over. Clearly you thought he was immoral. Everybody on that jury thought he was immoral. Nobody believed him. Sorry, Mr. Hunter.
Allegedly. Allegedly.
Whatever. It's an opinion. You don't have to say I have an alleged opinion. My opinion is that guy is immoral.
There you go.
And I can say that.
That's a better way.
Anybody can say that. Anybody can say that. Anybody can say, I think that you're a dick. I think that you're immoral. I think you have no soul. That is not defamatory in any way. It's just an opinion. And somebody else can have another opinion. It's fine.
Juror number 1 went on to say that he will not be coward sick when challenged sick by evil. As the French say, he will not be challenged by evil. I've got your challenged right here. Meaning he will not concede his involvement in the impropriety evidenced by facts discovered by the defense post-trial. Post-trial impropriety. If that persists for more than 4 hours, please consult a physician. We can't have that that post-trial impropriety. The internet community is reading juror number 1's posts, which are contributing to an eroding confidence in the jury system and the verdict in this case.
Is it though?
Is it really? Yeah, right.
Or are we proud of this jury and we're happy that they paid such close attention and came to the right decision?
Yeah, are you sure it's eroding confidence in the jury system?
I don't think so. They helped me.
Either.
I believe the opposite. I was very happy with this jury.
Oh, hey, wow. This is one of these rare instances where a juror is speaking. Now, in addition to the obvious hostility towards defendant and its attorneys on the part of juror number 1 and his wife, and their bias in plaintiff's favor revealed by the post, the internet community is now even accusing the court of sharing in that bias.
What?
Well, go ahead. Just accusing, whatever.
What?
Probably the Reddit community.
Accusing the court of sharing in what bias? Bias against the defense? Bias towards the plaintiffs? Oh, for fuck's sake. Who wrote this? Probably Shapiro. I don't know. This is stupid.
Juror number 1's statements, as well as numerous other comments he has made surrounding the content of the motion for new trial based on juror misconduct, etc., reinforces defendant's belief that juror number 1 was and continues to be biased against defendant. That statement
now. I mean, let me ask you something. So in the time that he wrote that, had the defense already filed the motion? I bet they did. They've already filed the motion accusing juror number 1 of all this misconduct. And then they're wondering why he made a public post on Facebook calling them evil while they are investigating his wife, investigating his background, investigating him for doing his job. Yeah, he has a right to call that evil. He has a right to call that immoral. It is. It's both of those things. Both of those things apply to the situation. Sorry, but they do. Actually, I'm not sorry. I'm not sorry. Not sorry at all. They apply. I'm done now. You made me
somehow I doubt that. We still have a page left.
Sorry.
Somehow I doubt you're done.
Why is Nikki Haley texting me? I do not want Nikki Haley texting me. Stop. I hate those mass texts. I don't know. She's running for president or something, and I don't care.
Oh, okay. All right.
She's sending out those mass texts, please help me with my campaign. No.
See, she's not done. This has nothing to do with what we're reading. She's not done yet. She's continuing. We still got a page left. Those of you that are afraid you're not going to get another rant, we still have a page left. The statements also suggest that if interviewed, juror number 1 will respond with a self-serving denial of any bias or misconduct.
Huh.
Self-serving. Denial must be self-serving because he clearly did it, wink, wink, nudge, nudge. Mm-hmm. Or maybe it's just actually a denial because it didn't happen. Mm-hmm. But that's not an option for that. It's not an option for the defense. Mm-hmm. But his posts reveal a fundamental failure to appreciate that juror misconduct warranting a new trial arises even where there is an appearance of impropriety, as has occurred and continues to occur in this case. He's not a juror anymore. As noted in the motion, no amount of indignation and denial of misconduct on the part of juror number 1 can erase the image of impropriety his words and actions and those of his wife have created and continue to create.
Does
They
it
look to
really
bring
say
us-
it those of his wife? Oh
Yeah.
my God. They really
It
do
does.
not like his wife.
No, and she has nothing to do with this. Not
She
a
has
damn
nothing to do with
thing.
it. Nothing to do with any of it.
Defendant suspects, they want to bring him in to question him to go on a fishing expedition to see if it really happened. Suspects that juror number 1's posts and inappropriate behavior, creating a mistrust in the judicial process, will continue, and that additional evidence explaining the source of his bias against defendant and in favor of plaintiffs will continue. Defendant therefore reserves the right to supplement its motion with such additional evidence as it comes to light. Right.
Okay, I
Howard
sent
Hunter.
you 2 exhibits. They're short. There's just the internet posted, the Facebook posting of juror number 1, so we can read the whole thing, which I thought was quite good, frankly. There's nothing wrong with him responding to these people, if he wants to. They have gone after him. They've gone after his wife. They are now smearing him with a 20-year-old allegation of child abuse that came out of a divorce case. Which they have no information of whatsoever. And they also failed to mention what was the voir dire question that they say he didn't answer. Boy,
Yeah.
don't you find that interesting, Jeff?
Okay, you sent Exhibit A, which I'm not going to show because it has the other party in the alleged domestic
Right.
violence thing.
But
It has,
look at the date. Look at the date it was
Yeah.
filed.
well, there's a few things to look at here. Just noticing it's got her name, so I'm not going to put that up.
Right.
The date was July 22nd, 2002, and
20 years ago.
it was dismissed due to the petitioner failing to appear for a hearing.
Oh, so the person who accused him of this thing didn't show.
Did not show up. Exactly.
Aha. Oh. Wow. Wow. So most likely there wasn't an investigation then. There wasn't anything in that case.
There-
All right. So look at the second
Yeah.
one. The second one is the Facebook posting, and that one you should be able to put up. I don't think there's anything on there that we can't see, but check it just to make sure. Otherwise, you can just read it.
Let's see. We're here. I didn't get an attachment for the second one.
What? All right.
I only got one attachment for Exhibit A.
All right, here. I'll just read it to you. We don't have to put it up.
Okay.
I'll just
Well,
read it.
you can pull it up on your.
'Cause I have it. I can't. I don't have it on my computer. I have it on my phone, so I can't pull it up. All right. This is what he posted on the 23rd. What you have accused me of occurred after Judge C released all jurors from their oath and duties. I will not have my legal and constitutional freedoms limited by the tyranny of an immoral person such as Hunter or the client that he works for, Johns Hopkins All Children's Hospital. The statement you made is, in my mind, that of a tyrant, interacting and paying a pro-plaintiff form. So he's responding to someone in the Facebook group, and we can't tell who because it's blocked out. Appears that you agree with limitations on free speech. You mention optics. Optics is a word used by people that know no facts and use other people's biased opinions to formulate their own uneducated opinions. I strive to high morals, respecting others, questioning everything, everyone's words and intentions for my safety and that of others. Always have, always will. My mother, father, family, and faith in God have made me what I am today. A law-abiding, good-willed American citizen that will not cower when challenged by evil. That's it.
I'm not seeing much. I'm not seeing a problem.
No, of course there's no problem. He can say whatever he wants post-verdict. We have established this. There's nothing wrong with him defending himself. There's nothing wrong with him standing up for himself. No.
I'm not. Yeah,
Oh,
I'm not.
and by the way, my locals chat just found on that Reddit page that they are the ones who dug up the domestic violence case and posted it on Reddit.
Disgusting people.
The defense is getting all of their information from Reddit. And by the way, those of you engaging in this Reddit page, you have a lot of nerve. doing stuff like this. You should try to put yourself in the shoes of a person that you're doing this to. What did he do to you to make you go and dig this stuff up? Why do you care about a hospital so much, this big corporate conglomerate, this big business conglomerate that is obviously harming people and harming children, that even had an immediate jeopardy shutdown because their surgeons weren't washing their hands and they were killing kids in the heart surgery center because of it, and infections were spreading? What in the world would possess you to go out of your way to defend people like that?
Well,
God forbid you should ever get stuck in a hospital like that. God forbid.
I'd even narrow it further and go, why? What have you got against juror number 1, who sat with 5 other people, listened to the same evidence, listened to the same stories, listened to the same testimony, and came to the same decision as the other 5 people? Is it just because he came out and he's saying what was going on and what the thought process was and speaking out? These are the same people that will watch the Amber Heard trial or other trial and go, why aren't the jurors speaking? Why aren't the jurors talking out? I want to hear what the jurors have to say. And then when the jurors come forward and do it, you do this bullshit. This is some snaky shit. Especially, to bring up these allegations of something that happened 21 years ago. That was ultimately dismissed because the person making the complaint didn't even show up.
Locals, I love you.
Nice. That's fast.
So much.
That's good.
I know. I know. Oh, locals.
So think about this people there on Reddit. Every time you complain that jurors aren't explaining things, jurors aren't coming forward, and jurors aren't talking, this is why. It's on you guys.
Yeah.
For all the things you hate Megan, you apparently hate me because we got early access to this. But I'll tell you what, I don't care who wins or loses. I wouldn't do shit like this. This is low. This is just, it's scummy and it's low.
It's low. It's really low. Oh, so we have the voir dire. We have his voir dire.
Well, yeah, we have the questions. It was like the first exhibit in the other deal, but it doesn't say which one of those questions they're saying he didn't answer.
There aren't a ton of questions. There's, do you have any family members? Okay, no. Do you or any close friends? Oh, here, maybe this is it. Do you or any of your close friends or family members work for or have worked for DCF? He said no. Have any of your close friends or family members had a child sheltered into protective custody by any government agency? He said no. Do you hold any strong opinions concerning Florida Department of Children and Families or its ability to take children into protective custody? He said no. Do you or any of your close friends? Oh, and then it goes into the hospital stuff. So those are the only questions about DCF that I'm seeing. And he said, so do you have any kids who were taken custody of? The answer is no. Do you have any strong feelings? He said no. He probably just has strong feelings about the ex-wife who accused him of those things, I would imagine.
Yeah, and they didn't even show up, so...
Yeah, so that didn't go anywhere.
Yeah.
So I don't think that's being dishonest on the questionnaire. They're reaching, Jeff. They're just going to keep reaching until they find something, I guess. But this is really it's
scummy to do this to a juror.
So scummy. And I believe it's jury intimidation. I think the judge ought to sanction them for doing it. I think that this is a very bad precedent that their attorneys are using Reddit to do their dirty work and investigate someone and go after them in a 4chan style, all out attack on his history and life. Wow. It is harassment and intimidation.
As I said at the beginning, I enjoy differences of opinions. I enjoy spirited debate. I like people that think differently than me. I actually found some of the comments on the Reddit thing amusing, but it's just low. It's just, why? Be better. Just, ew. I don't understand the mindset. I don't get it.
Yeah, me either.
Why would you want? What pleasure do you derive in going after a juror who sat with 5 others and reached the same conclusion. And he's explaining why. He's explaining his feelings.
How do we know they're using Reddit? Because this is where all the information came from. All of the information, all of the screenshots that the defense shared in the 144-page motion, the first motion that was the 57 pages or whatever, all of the screenshots came from Reddit. It came from this page. We can go back and look, and they're posting all of this. Look Shapiro, look what we found. And then he copies it and pastes it into his motion. It's undeniable that it all came from Reddit.
Icky. Well, we did it in 2 hours, Megan.
Wow. Great.
We did it in 2 hours.
Great, good. Because I've got a lot of I've got other stuff to get to today, and I'm going to be monitoring whether that hearing is going to be televised and what time it's going to be. And if it is, I will start streaming. So just keep an eye on my locals, meganfox.locals.com, where you will get the notification if I'm going to go live. All right. Sound good?
And it sounds good to me. And for all of those of you that are getting comfortable seeing things happening over here, we got through the motions. It ain't my show no more. It's going back to Megan Fox's show. It's back to you, Megan.
Thank you so much for doing
Fox.
it, Jeff. It was wonderful because, I didn't want to have to go through that myself. I appreciate your legal opinion on all of these things, and you're wonderful.
I was just doing holiday duty because we don't have Thanksgiving here in Korea at this point in time. There was no holiday. I wasn't traveling. I wasn't doing things. So I got, hey, do this. So I did this. This has been Megan's from beginning to finish. I'm not usurping her position. So
I love that you're interested in it, though, because it gives me somebody to talk to about it who knows this.
I will be participating on Megan's channel as she continues on with this as much as I'm able to. And if there's emergency situations, I might be able to take over for her. But we're on such different time zones. It's 3:15 a.m. here now.
I know. You need to go to bed so you can get up and go to work tomorrow.
Yes, Lat Cali girl. I am in South Korea. It's 3 a.m. here, 3:11 a.m.
Jeff's in the future. It's kind of amazing.
I'm in here tomorrow. And so what we've got coming up here is we'll wrap this up and we'll talk about more as things go along. But tomorrow we're going to be checking out some developments in the YNW Melly double murder retrial that's expected to start the opening statements in February 8th. Wednesday will probably be a Murdoch update. Thursday, we're going to be doing O.J. Simpson closing argument retrospective. We're going to be breaking down the closing arguments for the plaintiff, for the prosecution and defense in the O.J. Simpson trial from 28, 29 years ago. Not sure what we'll do on Friday, but we'll do something. So there we go. That's my future. And while we're talking about it, make sure you go to, again, meganfox.locals.com to get all of the updates on this and other things and what she's doing and all of her activities, because she's the primary coverage person that you should be looking at. She takes it seriously, but with a little bit of a snark on the edge. We got a couple of memes and some pretty funny memes. Bad weather. Okay, let's give our big foghorn to everybody. Thank you so much to this group of supporters. Bad Weather Biker says JHACH lawyers are almost acting like they're lawyers for a New Jersey waste disposal company and will get their legs broken if they don't get the money back. Tracy Melody, juror number 1's questionnaire is on the exhibit list on the document. We saw that. We checked it out. We just read it. But the only question it could possibly be would be, do you have strong feelings against them? And he said no. So
he said no. So
prove him wrong.
Prove him wrong. Yeah. He's gonna. And they ask him again. He's gonna probably say the same thing.
It's a bad motion. Life according to Martin. Vice's sounds horn announces Megan on the rampage. It's the Megan battle cry. And Marianne, which juror would have been slain if number 1 was let go? What?
I don't know, but that's a funny mental picture.
Tank rat, $20. Listen to this. F the defense lawyers. Calling out juror number 1 for free speech after being released by the judge is a-hole, and the rest of this BS was garbage. All right, that's a good reason, logical argument.
Too long, didn't read. Yeah, summation of the whole thing. It works.
Oh, the voir dire question was regarding knowledge or viewing. No, they were saying it had to do with his experiences with a DCF.
Right. I mean, they also don't believe him that he didn't see the thing.
Yeah, that was in the original motion. The supplementary motion was his dealings with DCF. All righty, folks. It's that time here to wrap this up and call it an early morning for me and a day for most of you where you're all at. Thank you so much, mods, for being here. Thank you so much, Megan, for joining me and for somehow forcing me into doing this. I'm not sure why I'm thanking you for that, but thanks. And for those of you that haven't hit the like button, how did we end up here? We currently have 1,406 viewers. Well, okay, we just dropped down to 1,204 because we're ending. We've got 931 likes. Do me a favor, 70 of you just on the way out here in the last couple seconds. Just hit 70 of you, hit the like button. Let's get us to 1,000 in the next 10 or 15 seconds while we wrap this up, because that'd be fun. Why not? Thank you, mods, for being here. And subscribed if you haven't already subscribed. I would deeply appreciate it. This is what we do. We do stuff like this. We do the motion reviews. We do trials. We look at things like I said, Y&W double murder trial, the retrial coming up. We got Murdoch coming up. Sarah Boone is supposed to be coming up starting in a few weeks. Follow, subscribe. Take a chance on me. Take a chance. We'll see y'all tomorrow. Thank you so much for your support, guys. Love you guys. We're out of here. And we will see you tomorrow. And go check out what Megan's doing on meganbox.locals.com. Lorax saying, get out of here. Go do something. I'm stalling while I bring up my outro.
Don't you hate it when you can't find the outro fast enough? It's like, and
plan stuff. All right. There you go. And just remember,
go to
defense.
How dare you?
Bye.